Good evening, everyone, and welcome to tonight's Constitutional Conversation Basement Edition. I'm Mark Storsley. I'm the Executive Director of the Constitutional Law Center, and it's my pleasure and my honor to welcome you, especially on behalf of our Director, Michael McConnell, who can't be here tonight. But we're especially delighted that so many of you came out to see one of the Constitutional Law Center's own, Ilan Wurman, who's a non-resident fellow at the Constitutional Law Center right now, and to discuss a question that's, I think, really important and really perennial question among constitutional law scholars, the question that Ilan poses for us tonight: can a dead constitution bind the living? It's been a really important and perennial question, in part, I think, because it sort of meets up with the two basic challenges of written constitutionalism as we have it. One of those challenges is an interpretive challenge. If we have a written constitution, we have to have some way of trying to discern what those words in the Constitution mean. And this is typically associated with the theory of originalism that Ilan will say some things about, but that's the question about how we go about discerning the meaning of the Constitution is a really central question to any form of written constitutionalism, and especially in the last generation or so, where our disagreements about what those words mean can sometimes be pretty stark. But the question's also really important for a second reason, because it sort of gets to the core of why is the Constitution authoritative and binding. If we have a written constitution, we'd like to think it's a good idea to have one. And this question helps us get at that. I couldn't think of a better person than Ilan to help us navigate that question. So as I mentioned, Ilan is a non-resident fellow at the Constitutional Law Center. Most of the time he's not with us. That's the non-resident part. Most of the time he's a private litigator in Washington, D.C. Ilan's written a few articles appearing in various journals, including the Stanford Law Review. And he also recently wrote this book, A Dead Against the Living, An Introduction to Originalism, that he's going to talk about tonight. This is a really great introduction, as it says, to originalism. I mean, I've read a lot of scholarship about originalism, and I have not yet found a volume that just so carefully places all the scholarship about originalism in one place that makes it readable, understandable, that sort of grapples with the fundamental questions about constitutional interpretation and sort of normative constitutional theory that I mentioned at the beginning. And really does it in a lively way. And I think you'll see that text sort of corresponds perfectly with Ilan's personality. So anyway, please join me in welcoming Ilan.
Okay. Can you hear me okay? It says it's on. Good? Okay. Well, thank you guys so much for coming. Thank you, Mark and the Stanford Constitutional Law Center, for hosting me. I think I agreed with about 80% of what he said in the introduction, especially that last bit about the book. Actually, speaking of which, is there a place I could do some subliminal messaging? Maybe. So the way this is going to go, I'm only going to talk for about 20 minutes. This is a habit I picked up from when I was a student here at Stanford. We often went to lunches, and about 20 minutes into a speaker's talk, people would start leaving, corresponded about when they finished their free meals. So I'm only going to talk for about 20 minutes, and then I'm happy to get peppered with your softball questions. So well, thank you again for having me. So Thomas Jefferson wrote this rather famous letter to James Madison in 1789, in which he said that the earth belongs to the living. The earth belongs to the living, not to the dead. The dead have neither power nor rights over it. One generation is to another as one independent nation to another. Now, as I said, Jefferson's letter is pretty well known, and it's often been quoted for the proposition that we shouldn't be bound by the dead hand of the past, by the dead hand of the Constitution. That the Constitution should instead be a living, breathing document subject to changing interpretations over time. But what's often forgotten is that Jefferson wrote this letter to Madison, who replied. Madison wrote a letter back in which he said the following: "If the earth be the gift of nature to the living, then their title can extend to the earth in its natural state only. The improvements made by the dead form a debt against the living who take the benefit of them. This debt, Madison said, cannot be otherwise discharged than by a proportionate obedience to the will of the authors of the improvement. Okay, let's break that down. Translation? Yeah, Thomas, you're kind of right. The earth does belong to the living. That's kind of obvious. But it belongs to the living only in its natural condition. The Constitution is an improvement of such consequence, of such magnitude upon the natural condition of the world that it can't but form this kind of binding obligation against future generations. It forms this debt against the living. And the only way for we the living to faithfully discharge that debt is through a kind of originalism, by a proportionate obedience to the will of the authors of the improvement, he says. So who's right? Thomas Jefferson or James Madison? Well, you're all very sharp, and as you might have anticipated by my choice of book title, the book answers in favor of Madison, originalism, and the original Constitution. But to make the argument, we're going to have to do something that is so rarely done in the law reviews and so rarely done in the law schools. We're going to have to defend the founding. Because as I think we'll see as the talk goes on, a full defense of originalism requires also a defense of the founding. And to see why, let's start with a definition of originalism, since I'm sure you've all been waiting for this. And also because Madison refers to something that, if you're familiar with the literature, sounds kind of like an older, somewhat maligned version of originalism, like an original intent originalism, a proportionate obedience to the will of the authors of the improvement. Okay, I'm going to throw out something a little controversial. In the book, I actually defend this concept of original intent a little bit. But anyway, it's sort of beside the point. Today, I think most originalists would define originalism as follows. Originalism is the idea that we should interpret the Constitution with its original meaning. The meaning, in other words, interpret the words with the meaning those words would have had to the framers who wrote the Constitution and the public that ratified it. But I think originalism stands for an even more fundamental proposition. Originalism stands for the proposition that there is a distinction between what the law is and what the law ought to be. And that this is, in fact, how we assess the continuing validity of all laws, right? It could be the Alien Tort Statute from 1789. It could be the Defense of Marriage Act from 1996. The America Invents Act from 2012. I don't know, it's Palo Alto, right? We first ask, what does the law mean? What does it say? What does it do? What legal effect does it have in the world? And then we ask whether that law still ought to be the law. So originalism, I think, stands first and foremost for the proposition that this framework for looking at all law applies to the Constitution itself, which is also a law that we, the people, enacted to bind our legal officials. So the originalist position is that we first look at the Constitution and ask, what does it say? What does it do? What legal effect does it have in the world? What kind of constitutional regime does it create? And only then do we get to this other question. Should the Constitution still be our law? Is it a good Constitution? Does it form this debt against the living? The way these two questions are framed, it should be pretty clear that that second question is really the hard one. It's really the hard one. But if you delve into the literature, and please don't, the whole purpose of writing this was to sort of spare you that trouble, but 99% of the literature focuses on that first question. How do we figure out what the Constitution says or means? So we hear a lot about the philosophy of language, we hear a lot about semantic content, and I in no way mean to diminish the importance of that scholarship. But it seems to me the more trivial question. Dare I say, it even seems to be an easy question. So briefly, on that first question, The originalist position is that we figure out what the Constitution says, what it means, the same way we figure out what any law means, which is also the same way we would interpret any communication intended as a public instruction. So, interpreting a constitution is in principle no different than interpreting a recipe for fried chicken that you find in your grandmother's attic that happens to be dated from 1789 and was written in Philadelphia. Now, this analogy is not original to me. Gary Lawson drew this analogy in a very entertaining law review article called On Reading Recipes and Constitutions. If you read one thing on originalism after you've read my book, you should get Gary Lawson's article from the Georgetown Law Journal. But let's briefly go through it, because I think it's intuitive. Think about it. If you found this recipe for fried chicken, and it turned out to be dated from 1789 and written in Philadelphia, how would you interpret it? Well, you'd interpret it the way it would have been understood by the public to whom it was directed as an instruction, to the chefs to whom it was directed as an instruction. That means the meaning written at the time, the original meaning that was intended to be conveyed to these chefs and the public, and a public meaning. I mean, if it was a secret meaning, it would be a pretty poor recipe. Indeed. Now, there might be some special culinary terms of art. Of course, you have to consider the context. But at the end of the day, the exercise of figuring out what this recipe means, what kind of fried chicken it creates, is an exercise in discerning the original public meaning of the recipe. Now, that's not to deny the existence of indeterminacies. Right? There could be ambiguities, vagueness. The provisions could be written at different and varying levels of generality. So, for example, the recipe could say, add pepper to taste. Well, what the heck does that mean? Whose taste? And how much pepper would that exactly be? Would it vary from chef to chef? So it could be. It could be that the multitude of chefs who are faithfully trying to implement this recipe might arrive at a variety of different fried chickens in the real world. Now, this is a range of plausible fried chickens, right? But it's a circumscribed range. It's not an infinite range, right? You can't replace pepper with rosemary if you decide that that's better. I mean, you can sure as heck amend the recipe, but that gets to a different question. So I think interpreting the Constitution, or at least figuring out what it says, is in principle no different. It was intended as a public instruction to our legal officials. And so the exercise in figuring out what the Constitution means is an exercise in figuring out its original public meaning. Now, there is, in fact, indeterminacy, there is ambiguity, there can be vagueness. So it's possible. In fact, I'll just state, it is a fact, that faithful implementers, faithful interpreters of any given constitutional provision, given a particular factual scenario, might arrive at a range of plausible originalist answers. I almost sound like a heretic saying that. I think sometimes originalists too often make strong claims like, well, the originalism requires one right answer. I don't know if the world is that determinate, but certainly it can permit a range of plausible originalist meaning. A range, yes, but a circumscribed range. Easy, right? So, are we all originalists now? Yes. Good, one sold. Well, Justice Elena Kagan says we are. She says we're all originalists now. But I don't think that's quite enough. I think we have to address that second question, whether the Constitution is still a good Constitution, because the best non-originalist argument requires that we address it. Now, there are many bad non-originalist arguments, and there are pretty bad originalist arguments too, but put in its best light, I think the best non-originalist argument will take a look at everything we just said, and they'll say, well, gee, Gary Lawson, Gee, Larry Solomon, that's all well and good, but beside the point. We non-originalists, we don't dispute that there is this thing called original public meaning. We just dispute that the original public meaning should be given legal effect. We dispute that original public meaning should be the law. They'll even say, we grant you that ordinarily you look at a fried chicken recipe and figure out what it says with its original public meaning. We'll grant you ordinarily, I mean, they'll fight this a bit more, but ordinarily we look at statutes and decide what the original public meaning is. But if the fried chicken recipe isn't good, I don't know, if it turns out it has MSG, right, it's very easy to change the recipe or abandon it. And it's relatively easy to change an act of Congress. But they'll say, the Constitution is different. The Constitution is very hard to change. Yes, it has an amendment process. Yes, that's the first best world for changing the Constitution. But the framers didn't think the Constitution would be as hard to amend as it, in fact, has become by historical accident. So it's very hard to change this law. We could have a revolution, I guess, and just have a new constitution, but that's even harder. So they'll say, if the original constitution isn't a good constitution and should be changed, but it's really hard to change, non-originalism is not a crazy way to do it. It's not just about judges exercising their own independent modern judgments. It's often judges drawing inspiration from the acts of the political branches, assessing what Congress and the president think is or is not constitutional, which itself the political branches reflect, sometimes more directly than at other times, but public sentiment and popular sentiment. And so by this method, we can change the meaning of the Constitution through this piecemeal, evolutionary, precedential process that is more or less directly, but probably indirectly, responsive to popular sentiment. That's not crazy. That's really not crazy. I mean, that is, I think, the non-originalist argument put in its best light. So I think the only way to make the full case for originalism is to defend the original legal content of the Constitution as it's been properly amended. It's to defend the founders' work in the Constitution. It's to ask that question, does the Constitution create this debt against the living such that it still ought to be the law? Well, how do we go about answering that question? Which is a much harder question. So in the book, I submit that the way to answer that question is to ask, what does a constitution have to do to be a good constitution for a free society? What does a constitution have to do to be worthy of the name of a constitution for a free society? It's kind of astonishing how critical of a question this is and how it's either just assumed or not talked about often in the originalist literature or the law reviews. So in the book, I make the argument that the founders believed, and correctly, right, the founders believed that for the Constitution to create this debt against the living, it had to principally do one thing. It had to balance the two primary competing objectives of a free government. On the one hand, the Constitution had to create a regime of self-government, whereby we the people could govern ourselves through our representatives and decide what kind of society we want to be, economically, politically, socially, culturally, morally. But on the other hand, a constitution for a free society also has to protect a large measure of natural liberties. I mean, why would we get out of the state of nature into this thing called society if it turned out to be a raw deal? And well, these two objectives are in tension with each other because it's often the popular majorities that infringe on the rights of others. So it's no easy task to create a regime of self-government that balances these competing objectives. And here we might draw some inspiration from a really nice quotation from Edmund Burke that I somehow discovered after this went to press, so it's not in there, but you could always buy the second edition in addition to the first. But Edmund Burke said the following: "It's very easy to create a government. Compel obedience, and the work is done. It's equally easy," he said, "to create freedom. All you need to do is let go the rein. But to create a free government, a government that successfully balances these two competing objectives in a consistent and coherent work, requires a powerful and combining mind." In the book, I argue broadly, we don't go into too much detail, but in the book, I argue that the founders were remarkably successful at accomplishing this aim, at balancing these twin objectives of a free government through ingenious mechanisms that you know about, like the separation of powers and checks and balances, the enumeration of power and the division of federal and state power. The representative mechanism itself was novel, and the protections in the Bill of Rights that were the most essential protection for a free society. This wasn't the only way it could have been done, but it's very hard to do, and the founders did it remarkably successfully. So I think, to the extent we still believe that and agree with that, the Constitution does in fact create this debt against the living generation. However, the founders did also think, probably rightly, I think rightly, should be careful what I say, that the Constitution was worth nothing more than the parchment on which it was written, without first receiving the approbation of the people through an act of popular sovereignty, through an act of consent of the governed. It is this ground on which the founders are most often criticized. They are rightfully criticized as being all white, all male, landowners, and mostly slave owners. And this somehow should preclude us from being bound by their accomplishment, their achievement in the Constitution. Now, there is no use in sugarcoating the founding. They were white, they were male, they were landowners, and they were racists, and they were slave owners. But I'm not sure that that's enough to preclude us from valuing and even being bound by their accomplishment in the Constitution because we don't celebrate them for any of those things. We don't celebrate them for the ways in which they were like everyone else had been throughout history. The founders did not invent slavery. They did not invent the exclusion of women. They did not invent the exclusion of the poor from the political process. These things had been universal. We celebrate the founders for their achievement overcoming these historical limitations in important ways. The founders wrote for the first time in a foundational national document that all men are created equal, as a result of which writing, by the way, half the states abolished slavery between 1776 and 1789. That was the innovation of the founding. We celebrate the founding for creating the first free government of the modern world, and a government committed to equality under law at that. Remember, the Constitution abolishes property requirements for holding federal office. The Constitution abolishes titles of nobility and hereditary privileges. Those were innovations. And the body of people who would deliberate and reflect on the Constitution and the ratification process was broader than anywhere else in the world and than at any other time in history up until that point. We have, of course, we have progressed since the founders' time. And thank goodness for that. But I submit that we have progressed largely because of the framework that they bequeathed to us, because we stand on the shoulders of their achievement. And that achievement, I submit, continues to create this debt against the living today. How did I do on time? Was I under the 20? So before, I think I'll end there. Before I open it up to your pleasant questions, I'm going to talk a little bit about what else is in the book to maybe generate some questions. So the book talks a bit about the interpretation-construction distinction. This is a raging debate in the originalist literature. I don't really think there is a distinction. It talks about the founders' theory of liquidation, which is their way of resolving indeterminacy. This has often been called the conservative version of living constitutionalism. I don't think that's right. It talks about Brown v. Board of Education and how originalism can justify and does justify Brown v. Board of Education. It talks about the difference between textualism and originalism. I once attended a conference called Textualism or Originalism, and I think I was one of two people there who didn't understand what the difference was between textualism and originalism. So I take something of a minority view, but I claim there's no difference between the two, properly understood in the book. Okay, and all of that is only in under 135 pages, and only $20 on Amazon, or here today, there are some copies if you guys want for $20 as well. Okay, I'll open up to questions. I was told to please wait for the microphone. Thank you.
Ilan. Our lights go out?
I predicted hostile questions, but this is really some.
Okay. We only have one microphone, so I'll be playing game show host tonight, but if you do have a question, please just indicate so, raise your hand, get my attention, and I'll pass it over to you.
Thank you. Very enlightening. And the book is worth more than I paid for it.
You can give me a donation. Thank you. Just kidding. No donations.
Well, my donation is in the form of a question that will allow you to further elucidate and enlighten us on your intelligent interpretation of the importance of the Constitution, which is, right, that's the challenge also. So what were the contributions of the Protestant Reformation and the Scottish Enlightenment to the founders as they wrote the U.S. Constitution?
Okay, so I am not an expert on the Scottish Enlightenment, but what I'll do in the spirit of the book is sort of explain the competing positions. I don't actually talk about the Scottish Enlightenment in this book. So there is what I would say a widely accepted view in the academy, in the historical political science, I guess, that the founding was an amalgamation of different sort of modes of thought, including the Scottish Enlightenment and the moral sense, obviously that influenced Jefferson very much, the sort of civic republicanism of the ancient Greeks, the Whig oppositionists of the 16 and 1700s, and this Lockean natural rights theory. So my view is that they all clearly work together to inform the founders, but ultimately, I think they were driven by this vision of natural right, this idea that we only enter into society if it's a regime that protects our rights and enables us to govern ourselves. Obviously, the epistemology of Hume and others contributed to that whole sort of movement, the Lockean movement as well. But I don't think it was too influential. Arguably, it influenced Jefferson in the Declaration, self-evident truths. I don't know if that's the same self-evident truth as the moral sense of the Scottish Enlightenment. But in terms of framing the Constitution, I think they were driven primarily by the two objectives and that I described, and primarily a natural rights framework. Having said that, there's more literature than one could ever read on the Scottish Enlightenment's influence. So that's the best I can do at this stage. I asked for softballs.
So I'm trying to understand the metaphor a little better. So if the original recipe calls for exactly a teaspoon of pepper, and I claim that pepper is twice as strong now, and that therefore now I should make the recipe with half a teaspoon of pepper. Is that originalism or non-originalism?
Thank you, Stanford law students. So there are kind of two things at play here. One thing for sure is we are not bound by the factual errors of the founders. Right? What matters is what the founders wrote, not how what they thought they wrote would apply to the real world. So if they thought New Jersey, due to the scheme of apportionment, would get 12 representatives and it turns out to only get 10, that's that, right? If it turns out that the framers of the 14th Amendment, though this isn't really true, it's the Democrats in Congress in 1872 thought the 14th Amendment didn't require school desegregation because separate is equal, we are not bound by their factual errors, right? What matters, right? And this is, by the way, what I think is the case for Brown v. Board of Education. I think it's an easy case. I think it's an easy case. Once it became known what the purpose of these segregation laws was, once it became known what everyone in the Jim Crow South knew, that these laws were intended to keep one race of Americans in a state of permanent subjugation and inferiority, they are obviously unconstitutional if that is the aim and objective. So we aren't bound by factual errors of earlier interpreters or in that sense. Now, your question was a bit different. Your question really goes to what if the fried chicken recipe had MSG in it? That's really the question. It turns out the founders thought X, Y, or Z, and so they wrote X, Y, or Z into the Constitution, but it turned out that they didn't really understand X, Y, or Z. But what they said mattered. What they said is what the law is. So in that case, a teaspoon of pepper is a teaspoon of pepper. If it turns out that it's too strong medicine, I think in that situation it's a case to amend the Constitution. But if they said, no, that's what I'll say on that. Before I'm in training to be a law professor. I talk too much. So it's a very sneaky example, and I like it. I'm going to remember it. It was very good.
What's the position on parts of the Constitution that are ignored routinely? I'm thinking of the Second Amendment, a well-regulated militia. I see lots of...
Start over? I didn't hear the beginning.
How do you handle those parts of the Constitution that are ignored? A well-regulated militia. I see lots of militias. I don't see any regulation. I don't see a bureau of militias. And it's like people just, that doesn't make any sense, so we're just going to ignore it. What should we do with stuff like that? Militia today doesn't mean what it meant in the 18th century. It's a different animal. Mm-hmm. So how do we handle that?
So how do I feel about the Second Amendment? Getting a little hot under the collar. So just broadly speaking, what do we do about ignored parts of the Constitution? I guess it depends whether we have a choice to exercise the power and we ignore them because we've decided not to exercise. Like, I don't know, when's the last time we issued a letter of marque or reprisal? Maybe it happens regularly, but so I guess it would depend. If, though, I'm understanding the undertone of the question, which is that DC v. Heller was wrong because we don't have militias anymore, or is that sort of what you were aiming at? Or I just want to make sure I answer the spirit of the question. So I think the easiest way to answer that is to give sort of my tentative thoughts on what the Second Amendment requires. I do not talk about the Second Amendment in this book, though I think it would have been a lot sexier if I had. So I think from an originalist, textualist sort of point of view, the way the clause is written, I'm reasonably persuaded. Right? I'm open to being changed on this, but that there is a difference between the prefatory clause and the operative clause, right? So the prefatory clause, as they said in D.C. v. Heller, is a well-regulated militia being necessary for the security of a free state. Okay, then what? The right of the people to keep and bear arms shall not be infringed. Okay, well, that's the right that's protected. The question then becomes, okay, so what is the purpose of this clause? And I think the purpose of this clause was primarily to ensure that there would be an armed citizenry that could form militias in the event of some sort of government tyranny or insurrection or invasion, which is the reasons you could sort of bring out the militia. That's true. Now, a lot of originalists will say they also intended to protect a private right to bear arms. I actually think that's also right, but let's put that aside for now, because I think the argument goes, well, we don't really have militias anymore, so we don't need the Second Amendment, or we don't have to worry about foreign invasion, insurrection, or government tyranny, so we don't need this right. And that's what I would push back on. I'm a very cynical person. I'm very pessimistic. Just the last 3,000 years of human history has been a history of violence, war, misery, destruction at the hands of government power. I know I'm sounding like libertarian, right? Okay, government power, and at the hands of others. And we today think that we have become so enlightened that somehow that history, we're so beyond it. But just in the last century, we witnessed a Holocaust in Western enlightened Europe and bringing it back home. Just 50 years ago, again, an entire population in the Jim Crow South was subjugated and disarmed, not allowed to own arms, and oppressed, and often experienced mob violence. So I just push back on the premise that we somehow don't have to be worried about that concern. Having said that, obviously the Second Amendment, in light of that purpose, allows reasonable regulation, right? Tanks might be on one end, bazookas might be on another end, a pistol might be on one end, semi-automatics might be on one end. It's really, really hard to draw a line. And I don't purport to have an answer to that. As a defense, I'll just note that the Supreme Court routinely denies cert in Second Amendment cases, because after D.C. v. Heller, they've just decided they don't know where the line is. So it's really hard. It's really, really hard. But the only thing that I generally, when I talk about the Second Amendment, that I push back on, is I try to push back on this notion that we are somehow so much more enlightened than the last 3,000 years of human history would really suggest that we are. But I don't talk about that in this book at all. So if that triggers you in any way, well, that's a bad word to use in this context, but it's not in the book, I promise. Softball question, please, please. What is this? Stanford Law School or something?
Let's assume that people in general and those in this room are convinced of the intellectual purity and merit of the originalist kind of argument. Makes a lot of sense. But let's now also assume, instead of just 100 years, we're talking about 200 years for our chicken recipe or for our government, and we have 200 years worth of reliance upon the fact that there hasn't been adherence to that kind of principle. And in reliance of that, we still have the written Constitution modified very little from the original, and we do have the language, but in practice, we haven't been intellectually consistent. What is the intellectually honest and consistent way of dealing with that for the originalist in recognition of the fact that we're 200 years down the line with an understanding of government, with institutions that are stable, a system of property that at least in some way or other is understood and used in practice, all of the advantages of having civilization and government, and where do we go back to if you say, oh, that was all wrong, we need to change that to be intellectually pure?
Well, this is refreshing. So I'm here in Palo Alto, and I hear our government institutions are stable. This is, in a sense, kind of refreshing. But your point is very well taken, and it's a problem for originalism. This is why Justice Scalia famously said that he's a faint-hearted originalist. I think he tried to walk it back. I think I think he walked it back toward the end of his life. But it's a problem. So, and it's a case for prudence and statesmanship. There is clearly no easy way to go back and recover fully sort of this original meaning and original constitutional order as conceived by many originalists. I happen to think that national government power probably isn't quite as unconstitutional as many of these originalists often think, right? So first there's the premise question. Can a lot of the modern administrative state, modern federal power, is it really unjustified by originalism? So, you have some, like the Phil Hamburgers and Gary Lawsons, who say it's all unconstitutional. I'm more of the view that maybe it's only like 30% unconstitutional. Okay? So it depends, again, on where you think we have to go. But it's true. It's a problem. There are expectation interests. And I think the best thing a judge can do in that situation is overturn precedents only if they're clearly wrong. Right? There's always going to be some open question to a lot of these provisions, only if they're clearly wrong from an originalist perspective, and in a way that doesn't harm people who have relied on these erroneous interpretations. So that might mean undoing something slowly. If you think Social Security is unconstitutional, I don't know that I think that. I don't know how you're going to do that in like one Supreme Court decision, but maybe the answer is you strike down a minor extension of the law. It's a complicated problem, and this is also why the one big piece of the originalist puzzle I don't talk about in the book is precedent, because it is very hard. But in a nutshell, I think the answer is, for an originalist judge, you don't overturn precedent unless it's clearly wrong from an originalist perspective. And you have to do it prudentially. You have to do it carefully. Because if you're going to end up wreaking havoc on millions of lives, then that doesn't do much good either. So it's a hard question, and I don't know that 135 pages is going to give an answer to it in defense. Still waiting for that softball.
Thank you for your talk. So my question is, the argument that you've sort of given for originalism is this debt against the living, which kind of sounds like in social contract type of theory. I don't really see the sort of analogy to the recipe so much, because I don't think that the recipe analogy is just a sort of straightforward descriptive claim. I think that there's also a normative element embedded into that, and that's just making the decision that the meaning that we're going to choose is the original public meaning, whereas there's multiple ways to sort of, the source of the meaning could be numerous things and not just the public original meaning. So for example, like the Dworkin idea that there's a difference between a concept and a conception, and that the framers really provided us with concepts such as cruel and unusual punishment. That meaning can change over time. Or even like recent scholarship, like Professor Myler has a recent article about common law originalism, and Judd Campbell has a forthcoming article, Natural Law and the First Amendment, which both of them seem to suggest that there's actually, and I might be doing a little bit of my own interpretation of those articles, that there's no actual original meaning. There's only ways of sort of framing questions and thinking about ideas. So I don't know if you can maybe just bridge that normative gap.
Yep. So I agree with the first half of what you said. I think that's right. So the way I described this fried chicken recipe very warmly is, I think, the answer to that one question, the first question. How do we figure out what it says? And I still think in principle, though the second half of your question pushes on that, I still think in principle the answer to that question is you interpret the Constitution no differently than you'd interpret a recipe for fried chicken, but most originalists end there and stop. It's just what the law is, they'll say. And I don't think that's right. I don't think that's right. At least it doesn't address the non-originalist critique, which is, okay, we grant you there's this original public meaning, but that doesn't mean other things can't trump that original public meaning. I agree with that. You need a normative argument in defense of the legal context of the Constitution, in defense of keeping this Constitution the way it is, even though it's old and hard to change. And so that's what I did in the last, tried to do in the last few minutes of my talk. The second half of your question is much more difficult, right? It's a question of, can there really be any sort of human understanding and communication, or is everything dependent on someone's particular point of view? I think it's certainly true that the way you frame certain questions is going to lead you to certain answers, but that doesn't mean those answers aren't objectively true, right? So that's a hard epistemological question. I take the position that you all came to this talk because you presumed to get some insight or objectively useful knowledge about it, but if there's no such thing as a kind of standard objective public meaning, then we may as well just be speaking gibberish and not coming to this talk, right? I think that's a challenge to whether human knowledge is possible, objective human knowledge is possible, right? Of course, human beings have presuppositions and backgrounds that will inform their opinions about things, objective truth. That doesn't mean, just because these opinions differ, doesn't mean there isn't this sort of objective truth to concepts and meaning, the meaning of language. That doesn't say, again, that's not to say there won't be hard questions. That's not to say that it's going to be easy to figure out what the original public meaning is to every question. Maybe it'll have to be supplemented by something else. Maybe, right? Maybe it's supplemented by a presumption of constitutionality. If we don't know for sure, we presume that what Congress did is law. Or if you're libertarian, maybe you say, well, we don't know for sure, so we're going to have a presumption of liberty. The government has to really justify its act here. So there may be these open questions, right? But I do think that originalism answers some common sense and obvious questions, like the 11th Amendment, whatever else it means, was intended to overturn Chisholm v. Georgia. I think that's just true. That's just true, whatever else it means. Maybe you're right, and the scope of how much we can actually know is more limited than many originalists. That might be true. Then I'll go crawl in a cave, But I don't think that's right. I think we generally can know enough in order to have a well-functioning regime based on the written law. But maybe I'm wrong. Maybe I'm wrong. Maybe it's a noble lie of sorts that I just like to keep convincing myself of. But it's a very good question. Not a softball, though. It's getting hot in here. Whew. I should have talked for longer.
Going back to the Madisonian letter, ex ante, before the revolution, they had obviously inherited institutions and norms that were very important to they were standing on other giants' shoulders, and then they articulated these reasons for being able to kind of push that inheritance to the side or cut it down a bit. Why can't similar individuals living today use those similar reasons, the as-if contract theory, to lead a revolution via constitutional law? Right, the way you kind of posited it was like, okay, well, you can go grab a bunch of guns and overthrow me, that's fine, but why are they not justified working through the legal system? Because this isn't a system that they would have built if they were in a perfect state of nature.
That's a very good question, which I have a little quotation from Madison in Federalist Number 14 on pages 79 to 80. Again, only 135 pages. So to assuage, this is what I say, so to assuage his readers about the novelty of the Constitution, overthrowing the prior regime, the spirit of 1776, in response to the Patrick Henrys, who thought that the Constitution was a betrayal of their inheritance, Madison said the following in Federalist Number 14. It is not the glory of the people of America that whilst they have paid a decent regard to the opinions of former times in other nations, they have not suffered a blind veneration for antiquity, for custom, or for names, to overrule the suggestions of their own good sense, the knowledge of their own situation, and the lessons of their own experience. To this manly spirit, posterity will be indebted, the spirit of 1776. To this manly spirit, posterity will be indebted for the possession and the world for the example of the numerous innovations displayed on the American theater in favor of private rights and public happiness. So I think the founders were aware. They themselves were rejecting what came before them. So why can't we do that now? Why can't we have an Article 5 convention or a constitutional convention or just an amendment, or do it through non-originalism or through some constitutional moments like Bruce Ackerman? I think we can if we think the founders were wrong. But I ask you today, what did the founders get wrong in terms of the primary objectives of a free constitution? If you had to state the question any differently, balancing self-government on the one hand and liberty, natural liberty on the other, would you state that question any differently? Okay, maybe we think we should be protecting more rights, right? Maybe we think there should be a constitution that guarantees everyone a right to health care, guarantees a certain level of education. Okay, and yet on the other hand, we have these criticisms that the Constitution is hugely undemocratic because of the Electoral College, because of equal representation of the states in the Senate. They want a more majoritarian, pure sort of representative process, so long as they don't vote on things like health care or education, or all those things that a lot of these same people also want protected in the Constitution. So my view, I think the aim of a free constitution is still to balance these two objectives. Maybe the founders got it wrong in how they struck that balance. I'm just not so sure that they were, or that we would do it better. I think the virtue of the Constitution is that the founders didn't in fact require very much. They didn't protect that many rights in the Constitution because they knew we would evolve and progress over time. So they left it for the democratic process. Could we do it better? Maybe. But this is not an easy thing to do, constitution making. It certainly wasn't easy in 1787, wasn't easy in all the prior histories of revolutions and government framing. I'm not saying we can't do it, but the whole thrust of this book is to defend the way the founders did it.
I think we maybe have time for one more question.
I don't know, it's looking like 7 if I look like this. Good, the friendly in the crowd.
I really hope this is a softball question you've been waiting for, but a lot of people suggest, scholars among them, who suggest that you really can't consider the Constitution alone. You have to consider the Declaration of Independence and the Constitution together. What are your thoughts on that?
We didn't even plant that question, but I love that question. I love that question. So it's often said, okay, so there's a lot of confusion about the role of the Declaration of Independence. The Declaration of Independence is not binding law. Okay? There's no doubt about that. I don't think you look to the Declaration of Independence to help interpret the Constitution, but I do think, to figure out what it means, but I do think the Declaration matters for that second inquiry, figuring out what a Constitution has to do to be a good Constitution. Because I think the Declaration of Independence more or less set it out. The Declaration of Independence, this thought is not original to me in any way, but it's a very good thought. The Declaration of Independence was half a revolution. It established the principles that justified the break from the existing government, but it didn't establish a particular form of government in its place. It left it to the states. It left it to the Continental Congress to do an Articles of Confederation and subsequently a constitutional convention. And there are many ways in which a government could have been framed in 1787 that reflected the principles of 1776, consent of the governed and the protection of inalienable rights. Exactly that balance we've been talking about. It's often been said that the Constitution of 1787 was a rejection of the spirit of 1776. I think that couldn't be more wrong. The framers in 1787 were interested in only one kind of regime, a popular regime, a republican regime. And the question was how to make it a workable republican regime. How to make it a republican regime that remedied the vices inherent in republican government. How do you check against the possibility of mob rule? How do you check against the possibility of people getting together, passing debtor relief laws that absolves them of their obligations? Right? How do you create a regime in which the states will actually pay their taxes and call out their militias in times of invasion? So I think the Constitution of 1787 was that second half of that revolution. It was the frame of government that the founders came up with after looking at 11 years of experience in the state governments and the national Articles of Confederation. They saw all those governments had tried to be consistent with the Declaration in the spirit of 1776, but there were severe problems with it, and those are the problems that the founders in 1787 tried to remedy. They didn't try to create an aristocracy. Again, they abolished property requirements for all the federal office. They abolished titles of nobility and hereditary privileges. The founders were interested in a regime, a republican regime that remedied the vices inherent in republican government. There is no talk in the Constitution about kingship or tyranny, aristocracy or oligarchy, the two other sort of regimes and their corrupt forms in the Aristotelian scheme. It was all about republicanism and democracy, how to make that work. So I think the connection is that. So I think that's the connection.
Okay, please join me in thanking Ilan.
If you want, it's only